A federal judge just called the U.S. government's crackdown on one of the world's most important AI companies Orwellian, and this ruling could reshape how every AI company negotiates with Washington for years to come. Here's exactly what happened and what it means for you. Let's set the scene. In late February, Anthropic CEO Dario Amodei drew a line in the sand. He said his company's Claude AI model would not be used for mass surveillance of American citizens or for fully autonomous weapons. The Pentagon wanted unrestricted access. Anthropic said no. What happened next was extraordinary. President Trump ordered every federal agency to immediately stop using Anthropic's technology. Defense Secretary Pete Hegseth publicly called the company sanctimonious and accused it of delivering a master class in arrogance and betrayal. Then, the Pentagon slapped Anthropic with a formal supply chain risk designation, a label normally reserved for foreign adversaries like hostile nation-states suspected of sabotaging U.S. national security systems. That designation didn't just cut Anthropic off from government contracts, it forced every defense contractor, vendor, and partner that works with the Pentagon to certify they have zero commercial relationship with Anthropic. Think about that. One company refuses to remove its safety guardrails, and suddenly, it's treated like a foreign enemy. Anthropic sued. And on Thursday, U.S. District Judge Rita Lynn issued a preliminary injunction blocking the entire thing. In a scathing 43-page ruling, she wrote that the government's actions appear designed to punish Anthropic for publicly criticizing the administration's position. She called the supply chain risk label likely unlawful and arbitrary. She said Anthropic's due process rights were likely violated because the company never got a chance to respond before being blacklisted, and she used a word that doesn't show up lightly in federal court opinions: Orwellian. Her exact quote: "Nothing in the governing statute supports the Orwellian notion that an American company may be branded a potential adversary and saboteur of the U.S. for expressing disagreement with the government." Why, the injunction is stayed for 7 days to give the government time to appeal, but the ruling is clear. The judge found Anthropic is likely to win on the merits. Now here's where this directly affects you. If you're building on AI platforms, selling to government agencies, or advising companies that do, the rules of engagement just shifted. First, vendor risk profiles just got more complicated. Before this dispute, Anthropic was the only AI company cleared for confidential military use. After the blacklisting, OpenAI quickly signed its own agreement with the Defense Department. If you're a defense contractor or government vendor, the injunction means the Anthropic ban is paused, but nothing is settled. You could be forced to switch AI providers and then switch back. That kind of uncertainty has real costs in integration time, retraining, and contract renegotiation. Second, if you're an AI startup or a technology company selling to the federal government, this case establishes that the government cannot weaponize procurement designations to punish speech. That matters. It means your company's public positions on AI safety, ethics, or policy disagreements have First Amendment protections that a court will enforce, even against the Pentagon. Third, the broader tech sector has largely backed Anthropic. That signals an emerging industry consensus. AI safety restrictions are a legitimate business practice, not grounds for government retaliation. If you're evaluating AI vendors, companies that maintain safety guardrails may actually be more legally resilient, not less. But let's be clear about the risks. This is a preliminary injunction, not a final ruling. The government has 7 days to appeal, and this fight is far from over. There's a separate Anthropic case still pending in the D.C. Federal Appeals Court. If the government wins on appeal, the supply chain risk designation could snap back into effect. And the judge explicitly noted that the government is free to simply choose a different AI provider. The Pentagon doesn't have to use Claude. It just can't punish Anthropic across the entire federal ecosystem for saying no. There's also a subtler risk the lawfare analysis flagged. Even if the First Amendment argument looks strong on the surface, the government could argue it would have made the same decision regardless of Anthropic's public statements, based purely on the company's refusal to accept the all-lawful use contract term. That's a harder legal question, and it hasn't been fully resolved. So, what should you do right now? 1. Audit your AI vendor dependencies. If your organization uses Claude or any Anthropic product in government-adjacent work, map exactly where that technology sits in your stack. Know your exposure if the legal situation changes again. 2. Review your federal contracting language. If you're a defense vendor, check whether your current certifications reference Anthropic specifically. The injunction pauses the ban, but the underlying dispute is live. 3. Track the appeal timeline. You have roughly 7 days from Thursday's ruling before the government must act. Set a calendar reminder. The outcome will determine whether the ban stays lifted or comes back. 4. Stress test your AI procurement strategy for political risk. This case proves that government AI policy can shift overnight based on political dynamics, not just technical merit. Build optionality into your vendor agreements. And 5. If you're an AI company with safety policies, document the business rationale for those policies now, separate from any political or public advocacy. If you ever face a similar dispute, you'll want a clear record showing your restrictions are driven by product integrity, not politics. Here's the bottom line. A federal court just told the U.S. government it cannot brand an American AI company a national security threat for disagreeing with how the military uses its technology. That's a precedent-setting moment for the entire AI industry. If you want to stay ahead of how government policy, legal battles, and AI safety collide, subscribe to AI Blueprint. We break down the developments that actually matter for your business. Hit subscribe, and we'll see you in the next one.